Well, hello there. Happy Thursday. Happy Thursday to you on this October 21st. Bill O'Leary coming to you from Legacy Planning Law Group, an estate planning, elder law, and probate attorney. And I'm coming to you live as part of our Thirsty Thursday series. So some of you may know, some of you may be stumbling across this for the first time. Our Thirsty Thursday series is a weekly thing where I talk about just various topics that sort of relate to the kind of law that I do. Again, wills, trusts, and estates, elder law, helping our seniors with planning, and then dealing with the probate court system. So, if you're thirsty for knowledge, you've come to the right place. Today's topic is how to plan for a loved one with special needs, part 2. So last week I had part 1, and now I'm continuing this. There's just so much to talk about. I really couldn't do all of it in one sitting. So now it's part 2. So here are some more tips to keep in mind when planning for your loved one with special needs. Okay, so let's first focus on retirement accounts and life insurance policies that you may have that you may want to pass on to your special need loved one. You know, there are certain assets that don't pass through a will or through a trust when you die, but instead will pass directly to them by what's called a beneficiary designation, beneficiaries that you may designate on a written form. These assets that can pass by beneficiary designation include retirement assets like IRAs and 401ks and so forth, as well as life insurance policies. Annuities would fall into the same category. So when discussing your overall estate plan with your legal team, it's important to consider these assets as well as the assets that will pass through your will or your trust. Now, naming a special needs or disabled individual as a beneficiary on a retirement account poses potential problems for their continuing eligibility for government benefits that they might be getting. Think SSI or Medicaid are the two most common, as well as it has sort of potential problems with tax consequences. So here, with these retirement accounts, you may want to consider naming other children or other loved ones as beneficiaries of these accounts instead of your special needs loved one, then providing an equalizing gift to your disabled loved one on other assets or other property that come from another source, okay? But if you really want to name your special needs loved one as a beneficiary of this retirement account, then you have to do it in the right way. This involves setting up a trust, and as part of this trust, you want to set up a special needs trust within that larger trust that we call a revocable living trust. Set up a special needs trust that's going to meet all of the tax rules. Okay, so that's what we call special needs trust planning. Now, with respect to life insurance, okay, it's important to use a special needs trust, okay, for the benefit of your disabled loved one, so that the trust can receive the life insurance proceeds. Okay, you should not name them as an individual, because imagine they get this payout directly from the life insurance company as an outright lump sum payout. Guess what it's going to do to the government benefits? It's going to disqualify them, kick them off the government rolls of getting those benefits, and that kind of defeats the purpose. Something else when planning for a loved one with special needs is to consider advance directives or guardianship. Okay, so once your loved one with special needs turns 18 years of age, they're legally an adult. They're what's called an emancipated adult. Okay, that means that you're not able to make decisions on their behalf anymore, despite their disability. Even though they need help, you cannot make these decisions without doing something to put that proper authority in place. If your loved one has the ability to do so, has this legal ability, the legal capacity to do so, they can sign what are called advance directives, giving you that authorization. And these advance directives can include a power of attorney for financial matters, often called a durable power of attorney, to again be able to make financial and legal decisions for them. Advance directives also include a healthcare power of attorney for medical decisions, also often known as a healthcare surrogate designation, and a HIPAA, a medical privacy release. You've heard of the HIPAA law. That's why doctors and hospitals, are very private about talking to people. A HIPAA authorization. Now, if they're not able to understand the nature of these important documents, or maybe the nature and the consequences of their disability, then a guardianship may be more appropriate. And the type of guardianship proceeding, it's where a legal guardian is appointed for the individual's lifetime, okay, or until maybe the circumstances might warrant releasing the guardian, maybe if they happen to improve. So that's where it's important to establish a guardianship, certainly for somebody who's under age 18 with a disability, but once they reach 18, that may continue on. Something else to consider is eligibility. Your special needs loved ones' eligibility for means-tested government benefits. Again, the two most common of these government benefits that are available to disabled people is number one, SSI, which stands for Supplemental Security Income, and then number two, Medicaid. And they are what's called means tested because they need to actually have a need for that and not have other money available to pay for their care or pay for their ongoing living activities and expenses. So the government has these benefit programs where they means test them. We can't have too much income, too many assets. Thus, the importance of having a special needs trust set up for your loved one so that they will continue to receive these means tested benefits, that the money in the trust is not going to be counted against them and kick them off the rolls. They'll continue to receive that benefit. Now, SSI, Supplemental Security Income, it's available to an individual that's deemed disabled by the Social Security Administration, number one. Number two, if they have less than $2,000 of assets in their name. And number three, if they have qualifying work credits. An individual receiving SSI is categorically eligible for Medicaid. So if you're getting SSI, you're going to be able to get Medicaid. Now, Medicaid, what is that? Well, it's a joint program. It's a sort of part federal and part state program. So each state has its own Medicaid program, but there's sort of a federal component that's uniform throughout the states. While Medicaid is available in all states, the asset and income allowances for Medicaid differ from state to state. So, for example, in Florida this year, 2021, the asset allowance for an individual residing in the community is $2,000, and the income allowance is $2,382 a month. If you have more assets than that, or you have more income, you don't qualify, but that's where the Medicaid planning attorney comes in to be able to sort of do some things, put some things in place in order to get them to qualify. And then I guess sort of the last thing I leave you with in terms of things to consider when planning for a special needs loved one is transition and advocacy. Transition and advocacy. Look, you're your loved one's best advocate, and understanding the rules, the local rules and the regulations and the SSI rules, the Medicaid rules, all that good stuff, and understanding the resources and supports that are available to your loved one, they're paramount, critical to this process of being the good advocate. Transitioning to the community when an individual loved one graduates from high school or turns 18, hey, it requires a lot of legwork. No way to get around that. There are government agencies in Florida that provide community support. So you may want to look into what those support options are. And some of them include residential placements, day sort of habitation, and vocational training and placement. So again, resources. Transition to turning age 18 and then being your loved one's advocate. You are the best one to do that. So again, some things to think about when planning for a loved one with special needs. So if you have a loved one with special needs or know someone that has a loved one with special needs and they don't know what to do or where to go or who to turn to, we would love to talk to you or talk to them. So I would encourage you to sort of take the next step and start a conversation with us by scheduling a phone call with us. We like to call it our discovery phone call. It's a 15-minute phone call. We don't charge for that, okay? And it's very easy to schedule that phone call. You know, you can call our office at 904-880-5554. Google us, LegacyPlanningLawGroup.com, or book it on the Facebook page. Just go to the Book Now button. So, hey, if you've enjoyed this video, I would kindly and humbly ask that you like it, or better yet, share it with your friends. Share it with your friends, particularly those friends that you have that may have a special needs level. I find sort of the special needs parent community is very tight, very close, very tight, and they share resources. So I hope you've enjoyed this this talk. You know, the part two, the second part on how to plan for a loved one with special needs. Next Thursday at about this same time, I'm going to give another talk. You know, same time, same day, just a different topic. So if you are thirsty for knowledge, as I like to close with, we will quench your thirst. So Bill O'Leary signing off for now on behalf of a fantastic team. The ladies I work with here, we call ourselves Team Legacy. Go make it a great day, and better yet, go make a difference. Make it a better world. See you next week.